Welcome to Proposal Bites, a series of short discussions on the key issues facing legal service providers when proposing for new business. My name is Sylvia Hodges-Silverstein. I'm the Executive Director of the Buying Legal Counsel. I'm speaking with John Forte, author of Winning Proposals, the Essential Guide for Law Firms and Legal Service Providers. Today, John, I want to touch on the subject of legal service providers rebidding for a contract they already hold. Given the advantages of being an incumbent and assuming they have a good relationship with their client, is it true that there is no real reason they should ever lose?
Well, I think it is true to say that incumbents have a pretty good record in many legal rebidding situations. Estimates vary. But I think probably across industry, the average is around 40% of rebidders who secure the contract for a second time or more. But 40% is obviously a long way off there never being any reason to lose. And in fact, I think firms have to work hard to make sure they maximize their chances of succeeding in that situation. Although the incumbent starts with a number of advantages, of course, that they are known to the client, they're likely to have a very good understanding of the client's requirements, there's an existing relationship and so on. There are also a number of threats. Sometimes the grass is always greener. Sometimes people are looking to refresh and have a change. So although there are advantages, obviously, from the client's point of view to continuity, it's certainly nothing that can be taken for granted, and they need to plan well ahead if they are going to maximize their chances of getting reappointed to the contract.
So what should the incumbents do to maximize their chances of getting reappointed?
Well, I think the most important thing really is to start thinking about the rebid almost immediately after securing the contract for the first time, and to plan accordingly. I think it's also very important to understand procurement's objectives and agenda, which may be slightly different from in-house counsel or other direct users of the service. Because I think what procurement is looking for example, is a sense that however well a firm might get on with the client, that there is some commitment to continuous improvement and finding improvements over the period of the contract. And that's something that the incumbent firm needs to think about. A very good way of achieving that, I think, is through client service reviews. So, for example, in the midpoint of a contract, carrying out a series of interviews, but perhaps through an independent party, to identify areas where the service could be improved or where refinements or greater efficiencies perhaps could be introduced, and then having time to implement those by the time of the next tender, in which case that firm will be generating some narrative on how they're committed to continuous improvement, and that will help them get a better score or enhance their score when it comes to the next tender. So I think it's all about long-term planning and thinking ahead, really.
Thank you, John. This theme is explored in more detail in John's book, Winning Proposals, the Essential Guide for Law Firms and Legal Service Providers. It's published by the Buying Legal Counsel, and you can get your copy on Amazon.com and Amazon.co.uk. Thank you very much for listening.